Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. Har Har Mahadev Jai Shiv Shambhu. This is a common query regarding the regular bail in anti-corruption cases. So to enlighten the subject, I entirely prepared the notes with your queries. So my aim is to enlighten you so that if you are having the legal trouble, you could easily encounter the same without any panic or worry. I request all of you to maintain the proper notebook with pen so that you could maintain your record accordingly. Question number 1. What are the governing sections regarding regular bail in anti-corruption cases? As we know that there is no specific provision under PC Act regarding regular bail. In addition to this, the rule governing the process of PC Act are not enacted by the concerned government or parliament as yet. So basically we have to rely on the protocol of BNSS. It basically governs the process to be followed while inclining the bill. As we know that the concerned court hearing the matters of anti-corruption is Sessions Court. So we have to apply as per the protocol of section 483 of BNSS. In case the bail plea is not inclined by court of session, means by the special court, then we have to move before Honorable High Court under the same protocol. So basically, in simple words, we could say that section 483 of BNSS governs the process of regular bail concerning the anti-corruption cases before Sessions Court or before High Court. Now I am coming on question number 2. What is the basic test for bail in prevention of corruption at cases? Basically, the arrest is required when there is violation of section 35 subclause 1 subclause B of BNSS on your part. For example, you have committed the cognizable offense in presence of police official. Number 2, you are going to tamper with the evidences. You are going to cause disappearance of the evidences. You are going to flee away from courts of justice, and you are causing impediment in the way of investigation. In that scenario, the arrest could be done. I want to specify that before doing the arrest, the reasons are required to be recorded. If the compliances are not done in that scenario, you could challenge the arrest plea. So basically, the court has to ensure that in case the bail is given, you would not flee away from courts of justice, and apart from that, you will not tamper with the evidences or you will not cause disappearance of the evidences. You may easily get the bail. And apart from that, you will not use your position to threaten or influence any witness. In that scenario, with the conditions, the bail plea could be inclined. So basically, I want to specify the special cases wherein you could submit your bail plea. You have to specify that there is no specification of the offense. In addition to this, if the allegations are serious, you are not having the plausible explanation, you could not be succeeded in your bail plea. Apart from that, if the offense is economic offense and huge monetary loss has been caused to the exchequer, to the public, in that scenario, bail plea could be declined. And apart from that, if the matter is under investigation, charge sheet is not filed, in that scenario, there are multiple instances wherein the bail plea has been rejected. So, safer course is to move the bail plea after filing of charge sheet in case we are going to move for the regular bail. So, in simple words, we could say that Section 482 of BNSS governs with the process of anticipatory. Section 483 of BNSS governs with the process of regular bail. And in case the charge sheet is not filed within time, in that scenario, the accused deserves the default bail as per the section of 187 subclause 3 of BNSS. We must remember that even though we are charged as per the Prevention of Corruption Act, the basic rule is of bail, not of jail. Even Honorable Supreme Court specifies that the detention of accused prior to conviction should not be a punishment. If investigation is over, charge sheet is filed, and you have cooperated, and there is no violation of Section 480 subclause 3 of BNSS, the case of accused might be a strong case for the regular bail. The common ground usually availed for successful bail plea are the rule of parity in case there are more than one accused. And if bail plea of one of the accused has been allowed on the ground of parity, the bail plea could be submitted of the co-accused so that he could get the benefit of bail. Apart from that, on health concern, the bail plea could be argued. In addition to this, if the accused is in jail since a long time and the proceedings are not going to be happened in the speedy manner, on that count, we could also apply for the bail. So basically, I have specified all of you the basis for the regular bail, how the bail is to be submitted, and in case the bail is not inclined by court of session, how to move before Honorable High Court. So I think that whenever you are having the trouble in anti-corruption cases, do not move in the anxiety. First of all, take the copy of FIR. Number 2, read it. Number 3, point out your specific role. Number 4, point out why the allegations are false. Number 5, draft the application in the proper way. You may take the assistance from expert also. And number 6, submit the consent plea, and if there is any reply by CBI, Vigilance or ACB, submit the rejoinder. Basically, we have to argue on the legal compliances, as I told you, section 35 subclause 3 of BNSS. And apart from that, we have to specify that there is no role. We have to specify that we are falsely implicated. So in this way, the chance to get the bill will be on the dominant side. See you in the next video. Till then, Jai Hind, Jai Bharat.